Let me know where you're tuning in from. I'm going to be talking about a not so fun topic today. Hi, Jude on Instagram. Hi, Facebook. Hi, YouTube. Okay, I'm going to jump right into it. If you guys have any questions, you can put your questions in the box. And then once I finish, I'll try to answer your questions. My name is Aisha Chidilwe. I'm an immigration attorney. I practice out of Orlando, Florida, and Atlanta, Georgia, but I present clients all over the United States with their family immigration matter. Your location doesn't matter. Your country, as long as you're trying to immigrate to the United States and you have someone that can position for you. Um, you can call me 407-995-6567, or you can send a message on WhatsApp 404-333-8751. Um, Good morning, Vicky here braiding on YouTube. Good morning, Sandra. Good morning, Brandon. Said I'm always excited to tune in. Awesome. Boo for the boo list. Good morning. So guys, I want to talk about the 90-day rule and just triggering it, you know. So let me start out by saying this. I'm sure a lot of you probably like, well, what is that? So, here in the United States, when you come into the US with a non-immigrant intent visa, I'll break that down in a second. There's certain requirements that they have of you, during the time that you're here. So I'm going to use a simple visa to explain that to you guys. So, when you come in with, let's say, a B1, B2 visa, a B1, B2 is either you're coming here for like business, pleasure, a quick medical trip, or whatever it is. It's also known as the visitor's visa. That is a non-immigrant intent visa. What that means is that they don't expect you to be adjusting your status. They expect that trip to be a temporary stay in the United States. Um, Now, when you're in the United States and that trip is no longer temporary, there's certain things that they look at to determine whether or not you would qualify to adjust your status or not. So, let me give you an example. So, again, you come on a visiting visa, and then, 1 month later, you start looking for employment, or you start trying to go to school, or you go submit a change of status to try and get, an I-20 or whatever it is so you can go to school, or you get married. Okay. um, or anything basically that would construe you trying to change your status into a permanent status. Any of those things that if you do them within those 90 days, automatically it triggers a 90-day rule. And what the 90-day rule for USCIS is basically that this person potentially has a material representation. A material representation is like a big judgment against you, or makes it harder or more difficult for you to get your green card. It's not impossible, but it makes it harder. So, I'm sure you guys probably recall when you came, through the airport or whatever it is. Oh, what are you staying here for? What did you come for? You know, if you end up entering into the country, I came to visit, and then, the next month you get married, and then you're like, okay, I'm going to wait 90 days and then I'm going to file for my green card. It's still going to trigger the 90-day rule because, again, you got married within that 90 days. So you want to make sure that, if that happens, you have a really solid, really, really solid reason why that happened. And I say this to say that it's not that USCIS will automatically deny you, but it would mean that instead of like a preponderance of the evidence, is more of a clear and convincing evidence where you have to convince them that you didn't make a willful misrepresentation, and truly you were not planning to stay here. I'll use an example of a client of mine who where we the person entered into the country, with absolutely no intentions of staying here permanently. And this happened during COVID. So I think, obviously the the COVID incident was worked in that client's favor. This is a client that kept coming and going, and had been married 2 years, but of course, when COVID happened, spouse was having a baby. It made sense that with COVID and not knowing if they would be able to ever, if he would be able to come and go, that he would stay here. So with that case, it was very easy to prove, that there was absolutely no intention. Here's a return ticket. I didn't plan or foresee that the borders were going to be closed, or whatever it is, and it was just safer to be here with my spouse who had a brand new child and not leave her alone when she can't leave the house, because if she leaves the house, she got to leave with the baby. It's not safe for the baby because the baby can't wear a mask. So in a situation like that is something that would convince somebody, and of course, convince um, the officer that that was a situation. But now that the borders are opening and we're seeing more, we're seeing, or I'm hearing from a lot of people who call me for consults, how their visa extensions, like they apply for like a visitor's visa extension, how they're being denied. Be, those who apply for extensions based on COVID, just because right now, most borders are open where you can travel, back and forth. So you want to be very careful with that. If you do anything after 90 days, it doesn't necessarily mean that they're still not going to question you, but at least the 90-day rule is not going to apply. They're going to just focus really on whether your marriage is legitimate, whatever reasons that you're trying to change your status or whatever you're eligible for. But so you just really want to be mindful about that, because I'm seeing a lot of that happen, more recently, where people think, okay, we'll get married, but we just want to adjust our status till 90 days later. But even the acts of the marriage, it's considered a it's considered something it's considered an act towards trying to change your status if you're married a US citizen within the 90 days. So if you must, you want to do it after that time frame. I see a bunch of questions here. So let me answer them. So Sandra Pepper on Facebook says, good morning, I just got married in January, can my husband start processing and until he gets the naturalization paper? I'm not really sure I understand your question, but are you saying that your husband is not naturalized? Well, the answer is going to depend on what your own status is. Are you here legally? Meaning, are you current? Are you here? One, are you here legally? Two, is your visa still current? Three, has it been 90 days since you've been in the country? So the answer to that will depend on whether your husband can file or not for you. But if the answer to those are no, you definitely want to wait till your husband naturalizes. Once your husband naturalizes, then he'll be able to do the adjustment of status. I mean, he can certainly file an I-130 for you, but as far as naturalization, as far as the green card, he must naturalize before he can do that for you. So, it all depends. Justina, and he says, good morning from LA. Thank you for all the information. You're the best. You're welcome. Um, all right, let's see what else we have here. I don't have a lot of time today. Um, so I'm just gonna see. Um, Jude says, I have a friend who's on the verge of dying here in Florida. Her husband ditched her and asked her for a divorce and moved out, left her. She's on the verge of losing her sanity and soon will not have any money to even live. Wow, that's really sad. Jude, the first thing that she wants to do is that she wants to definitely try and contact like maybe a women's shelter, a nonprofit organization, depending on her state, just to see if there's somebody who can, or an organization that can house her and help her. If her spouse is a US citizen, I definitely would love to consult with her just to see if she might qualify to self petition herself. But first and foremost, she needs to get somewhere where she's safe. Um, and I'm hoping that, what you're saying is that I'm hoping that she's not like suicidal. If that's what you're saying, maybe you as a friend can provide a suicide hotline for her, or help her, try to navigate that process. Good morning, Earl Jojo. Boo for the Bullet says, how many times can one file for Vowel? Oh, Adjustment of status. Well, I mean, I guess the answer really depends. There's no limits to trying out things, but you want to be careful what the reasons why you're being denied for stuff is. And if you're submitting the same application for the same person, let's use marriage for example. If, you if hold on one second, guys, let me remove this thing. So for instance, if you get married and you file with a US citizen and your case gets denied because they feel like that your marriage was trying to circumvent the immigration system, or they suspect that it was a marriage sham or marriage fraud, and then you guys get divorced, and then you marry somebody else like 5 years later, and you and that person have like 3 kids. You can file for adjustment of status, but trust and believe that the other case will come up. It just doesn't go under a rug. Like sometimes, people actually think that, whatever happened in their old immigration case is forgotten. USCIS keeps everything, all your file and everything is brought out at the forefront for everything that you petition for. So they are going to be like, well, yeah, that's great. This marriage is real, but let's talk about your old marriage. What proof do you have that that marriage was real? So sometimes that becomes a stumbling block for you from getting the other one. Now, if the issue was that you guys didn't have enough evidence the first time and you're filing again with the same person, by all means you can do that. The same applies for VAWA. Sometimes people come to me because their VAWA case was denied because they didn't they didn't do a good job submitting their application, and so strategically we then make a determination if refiling a new VAWA application or appealing it makes sense. Strategically, for me, if somebody has been divorced for like 2 years, by the time a decision comes out, we can't refile VAWA. So we must appeal that VAWA case. We must appeal the decision and provide more evidence to ask for a motion to reconsider. So like that literally pigeonholes you as the only option. But if the person is still married or they've not been divorced for 2 years, and you look at the totality of the circumstances, and if it's just easier to submit a new VAWA application, we'll submit a new one. So there's no real limit as far as time. It's just as far as how many, it's just what it is. um Chrissy says, I received my EAD card in 2020 and it expired in December 2021. Then I received a 100 days extension. Do you have any idea if the new card will come before the 100 days extension? I don't know. Listen, if I had an idea, I will be super rich because I will be telling everybody when exactly their green card, their work permit is coming. I don't know. Renewal work permits are taken an unusually long time right now. So it's really your guess is as good as mine. However, if you're a healthcare worker, so in December, expired in December. If you're a healthcare worker and your stuff is about to expire within 30 days, you can definitely try for an expedite. You can definitely show proof that you're a healthcare worker and ask for an expedite request, and hopefully that works out where they're able to get it for you. Okay. His wife, Nikki Thomas, says, oh my God, hello to the best lawyer in America that I know it's been a while because of work, but I'm happy to catch you. Hey, hey, hey. Awesome. So what if you prove the first case and all of that was successful and you marry someone else? Will the old case still be questioned? No, no. So let's talk about that. I actually called the office to this person that I'm talking to right now. Call the office today. I got some info for you, or maybe they've called you already. But so let's talk about that. So there is a rule where if you got your green card through marriage, you really should not be filing an I-130 for another spouse until either you've had your green card for 5 years or you become a naturalized US citizen. Or you can show by clear convincing evidence that the first marriage you didn't enter it due to immigration fraud or sham, right? Like this meaning you literally don't qualify. So if you're a green card holder and you get to, even if your marriage was approved, and you get divorced, or whatever it is, you cannot file for somebody else if you've not been a green card holder for a total of 5 years or you're not a US citizen. So let me make that clear, okay? Unless you can show, sorry, the other exception is if your spouse died, unless you can show by clear and convincing evidence that that was not the purpose of you entering the marriage. So you want to be careful with that. So last question. If you become an American citizen and want to remarry, you can only sponsor 2 people for K visas in your lifetime. Can you please break down for me? Well, how? So I guess the question. I'm not sure if I understand your question. So when you say remarry, so you're a U.S. citizen, and did you sponsor somebody before, or did you file for a K-1 before? Is that what you're asking? Bukanla, I don't handle adoption. No. Um, Sherry says, "Good morning. Thanks for all the awesome work you've been doing. Last week I was approved for my green card through Vowel. Yay! I'm doing a happy dance for you. All right, guys, I gotta go. I'll talk to you guys later. I won't be on live tomorrow or Friday. I will be out of town on Friday, but I can't be on live tomorrow. I have super early meetings, but I'll probably do a live stream or do a replay so that for those of you that didn't catch this, you can catch it. If I didn't get to answer your questions, definitely call the office, schedule a consultation, and I'll be happy to chit chat with you then. All right, guys, have a good day. Bye.